to be on Try to Leg Your Attempt, and we are going to you know what I'm saying. Alright, when we get back, we'll catch this now. Alright, enough of the joyful, eventful mood. Alright, welcome to today's episode. So today's case is Chilufya Sata versus Zambia Bottlers Limited, Supreme Court Judgment number 1 of 2003. Now, the question before the Supreme Court of Zambia was whether or not negligence as a result of manufactured food or beverage arises not until there's consumption, and as a result of that consumption there's personal injury suffered, or it can happen before you just see the foreign material in your beverage or your food, and that is negligence. You have nausea, you faint, mental stress, or there has to be the aspect of indigestion, and as a result of that indigestion you suffer what we call personal injury as a result. Now, the brief facts of today's case are as follows. The applicant had purchased Sprite bottles in a crate from Melissa supermarket, which he then went and drank with his family, with his children. Now, they drank a few bottles, then they stumbled upon this one bottle, which one of them was supposed to drink, but they noticed there was a foreign material. There was a cockroach, whatever word suits you right. So they found that foreign material, and it's claimed that they had nausea thereafter, they fainted, they had to be treated. Now, Melissa Supermarket were not the people who manufactured and bottled the Sprite. It's very important you understand this. But it was Zambia Bottlers Limited. That is why they were sued as the manufacturer and bottler, because they had the responsibility to ensure that whatever they produce, because it was going not to the retailer but it was being sold to the customer had to get the best quality and without any foreign material. Now, Chilufya Sata commenced the matter in the High Court, claiming damages and obviously negligence from Zambia Bottlers Limited. But the High Court, applying the case of Donoghue and Stevenson, stated that the key ingredient of consumption was not visible in this matter, and the fact that they did not even consume that product, let alone that consumption, there was no proof that the consumption caused injury, even though they had taken the other sprites before this one. That could not stand, because you had to consume that one particular product, and after consuming it causes an injury, that particular consumption. He dismissed the matter and threw it out. So when we get back, we'll have a quick look at what the Supreme Court of Zambia said, and then we'll wrap up, hopefully. Alright, for now, let us enjoy some Bensound. Enough. Welcome back. So, the matter went before the Supreme Court of Zambia in 2003, and the main argument, there were other arguments. They looked at the Food and Drinks Act, Section 3, but for this particular podcast, we are looking at the negligence, law of tort in negligence relating to consumption. So, their argument was the court below erred in law and in fact, and they did not agree with what they said when they said the negligence arises upon the consumption of that beverage or the product or the food product, therefore leading to injuries. So they were arguing against what the judge had stated in relying on Donoghue versus Stevenson. Now, they stated that Micheal Sata and the children suffered mental injuries, discomfort, and mental distress, and they had to receive medical treatment having taken those drinks and then they saw this drink, they were shocked. However, the Supreme Court, having looked at all the evidence, began by, first of all, making reference to the case of Donoghue and Stevenson. If you read the full judgment, I'm not really sure if it's on App 20, not sure if it's there, but you can find it. If you read the full judgment, the Supreme Court started off by trying to make a comparison between similar cases that had similar precedents that had been set before and compared it with this case. So they cited one British landmark case of Donoghue and Stevenson relating to the manufacturer having a duty of care. The famous ginger beer in the opaque bottle where the snail was found at the bottom, and the person who drank it got sick as a result, went to hospital, and they were able to sue, and they were successful for damages, if I'm correct. I read a lot of Zambian cases, I can't remember Donoghue. But they also looked at the Zambian cases. They looked at Zambia bottlers, again, and Ruben Mwanza. This pertained to when, in this instance, the respondent, Mr. Mwanza, was having an alcoholic beverage. He drank the beverage. Upon consuming the beverage, there was a foreign material, a dead lizard, which got stuck on his throat. Then there was also the Continental Restaurants and Casino and a Chulu. In this instance, the respondent was given soup by the manufacturer, Continental Restaurant and Casino, and she started consuming the soup. Upon her consuming the soup, that is when she discovered that there was a foreign material, a cockroach, which then led to injuries. She went to the hospital and, well, she was compensated. Now that case, again, went into other issues that are not discussed in this case. But the whole instance the Supreme Court were trying to bring about was to say Micheal Sata's case was similar to these cases to a certain point. In all these cases, the foreign material was there, right? Yes. But one thing was missing. In Micheal Sata's case, there was no consumption. Meaning, they did not take or indigest that particular product. They did not consume it. And because they did not consume it, you can't claim injuries, because negligence and damage go together. They can't be apart. They coexist. And because they coexist, they failed to show that. Now the Supreme Court, allow me to quote from what the Supreme Court said. At this point in time in 2003, our Chief Justice was Ernest Sakala. He was part of the bench of three that heard this matter. The court stated, and I quote, beginning of quote, "We do not believe that it is permissible to extend those principles to a case of this nature where there has been no indigestion of the adulterated food or drink." So they upheld the decision of the Supreme Court. So meaning, a manufacturer will be held liable for providing, giving the customer food which is not fit for consumption. But in order for you to sue and be successful, you must prove beyond a balance of probability that it was that food that caused your damage or your sickness. We call it damage, but you can call it sickness. Your sickness. And you must do this by producing evidence to this effect. That I had consumption. As a result of that consumption, I have suffered damage from that consumption, from that food I bought from this particular store. These are the people that manufactured it. So the manufacturer now has a duty of care that whatever goods he is to bring out to the public are of a quality standard. They shouldn't contain any foreign material, because if they do, the customer suffers. So even though the retailer is the one that sold it to you, you're able to sue the manufacturer. That's why Zambia Bottlers Limited was sued by Micheal Sata, even though Melissa the one that sold it to him, because they manufactured and bottled it. So they are the ones who are responsible for it. All Melissa are doing is they're buying it from them, then they're selling it to you. 1. 2, consumer rights. A consumer has a right to quality products which will not cause them harm in any sense. In this instance, when it comes to the manufacturing of foods and beverages, the consumer must always be thought of by the manufacturer when they are producing their products. So they must not just make any product whatsoever. They must ensure it is of a quality standard. They must ensure there is no foreign material. Because in the event there is consumption of that particular product or beverage, and it causes injury and there is evidence to this effect, you can sue them. So the case also raised the issue of consumer protection, that we do have consumer protection in our country, that manufacturers must adhere to quality standards. I mean, if you look at the case of Ruben Mwanza, which they cited, and the case of Continental Restaurant and Casino, it showed you to say, whenever a consumer is buying a product, it must be of quality. If the consumer is affected by the product you've manufactured and they consume it and they get sick, they're able to sue you with the particular type of evidence. However, sometimes people will want to sue manufacturers, yet knowing that their intention is to make money. And it was highlighted in the case of Micheal Sata somewhere in the judgment. But today's aspect was to tell you at what point would you sue in the event that you unknowingly find foreign material in your product. How would you go about it? If you don't find, or if you find the foreign material before you open the product, the Food and Drugs Act Section 3 comes in and the manufacturer will be held criminally liable because he gave you whole, or they're not allowed to sell foods which are not of a suitable quality. But when it comes to you now consuming it, it's either you've consumed it wholly or partly, and as a result of that consumption, you suffer personal injury or damages. And you must therefore also have evidential proof, because it's on you now to prove to us. So, ladies and gentlemen, this is the end of our podcast for today. Thank you for tuning in, and I will see you